Thank you very much, Senator. Apologies for absence. Ms. Brandon, any apologies?
There are no apologies for absence, but there are 2 apologies for lateness for Senator Samuda and Mr. Robinson.
Okay, noted, noted. All right, some brief opening remarks. Just to update that the following entities were invited to make submissions on the legislation by the 31st of May 2021. University of the West Indies, University of Technology, Northern Caribbean University, University Hospital of the West Indies, Ministry of Health and Wellness, Ministry, Medical Association of Jamaica, Ministry of Education, Youth and Information. In addition, the clerk of the committee wrote to the following entities based on our discussions, inviting them to make submissions, and those were Jamaica Bar Association, Financial Services Commission, and the Jamaica Bankers Association, and Simtai Consulting Limited. Since the last meeting, the following 4 entities made submissions: Simtai, FSC, Ministry of Education and Youth and Information, and Jamaica Bankers Association. So to date, a total of 8 submissions have been received from the ODPP, MNS, PSOJ, MOCA, FSC, Simtai, Ministry of Education, and Jamaica Bankers Association. So we are proposing the next meeting for June 16th at 10 o'clock. And of course, at the right time, we'll determine which of the 4 entities should be invited at the next meeting. Also, we have a request from the University of the West Indies for an extension to June 18th to make a submission on the act. So we need to make a determination on that. Again, we'll do that further down in the meeting. University of Technology has committed to make its submission by June 2nd, which would be now. And of course, the minutes of the meeting held on May 13, 2021, and the agenda for the virtual meeting to be held today were sent to members. So we're looking forward to 2 presentations today. That will be that of the Ministry of National Security and the Office of the Director of Public Prosecutions. But before that, I would just like to get confirmation of the minutes of the meeting held on May 13, 2021. So as
Chairman,
usual, yeah, go ahead.
Just for the record's sake, the Ministry of Education withdrew its submission, and it has indicated to me that it will resubmit. The University of Technology has sent its submission today, and I had forwarded that to the members.
Okay, thank you very much, Ms. Brandon. All right, so as usual, I ask that members read the minutes prior to the meeting for confirmation. I don't know if there's any corrections or anything that wants in relation to the confirmation of the minutes. If so, members, you can raise it now in terms of any typos or anything. And if not, ask for someone to move.
I so move. I so move.
Okay, can I have a second now? Natalie? Campbell Rodriguez, is she on? You might be on mute.
Seconded, Minister.
Thank you, Dr. Longmore, Senator Longmore. Any matters arising from the minutes of May 13th? All right, no matters arising. That means that the minute taker is doing a very good job, obviously. All right, so today we have, as I said, two presentations. Minister of National Security, followed by the Officer Director, Public Prosecution. So without further ado, can we ask Ministry of National Security, and just for the protocols, when anyone is speaking, if they could have their camera on, since it's being televised, streamed on PBCJ, and also to mute your mics. Please mute your mics when you are not contributing so that we don't get any feedback in the presentations. So, Ministry of National Security, you can introduce yourselves and go right ahead. Thank you.
Thank you, Chairman. Can you confirm that you are hearing us? Mic check.
Do we have the Ministry of National Security? I see the screen, but I don't hear any voices. Check and see if you're on mute, please.
I just heard them asking if we were hearing them properly, but it was very low. So I don't know if they're having a technical issue.
I am not hearing anything at all. So, MNS, if you can check your system and see what's going on, but we're not hearing you. And some are hearing you very, very faint.
Are you able to hear me now, committee?
Yes, I've heard much better.
Better, but yeah, better, but not very, very, very loud. I don't know if it's my computer. Is anybody else hearing him properly?
But very low, Chair.
Okay, so you're making some progress, MNS, but you still need some volume.
Is this better?
Just a little.
Yeah, little
All right,
better. You can give me some volume, it'll be good.
Let me try. Microphone is almost in my mouth.
You check your volume. You check your volume on your set.
The volume is up, Chairman, so I'm not sure what the problem is.
It's very low though.
I'm going to mute this one and present from my.
Hearing you a little better now.
Better now.
Right,
Better now. Whatever you do, I'll keep doing it. Go ahead. Go ahead.
Okay. All right. So this is good.
Yes, it is. It is.
Go ahead. Go ahead.
All right. So a pleasant afternoon to you, Chairman, and the committee members. My name is Michael Morgan. I am the Policy Director for the Ministry's Cyber Intelligence and Incident Response Branch. Excuse me. What's his name? You're seeing my screen, right?
Yes.
Okay, great. All right, so I'm just going to allow the other members to avoid any further technical difficulties, let me just do the introductions. So also with me is my cybercrime policy specialist, Ms. Trezana Gordon. On the MNS side, we also have Ms. Evian Francis, who is our senior legal officer. I have Deputy Superintendents Dwayne Daly and Warren Williams from the Communications, Forensics, and Cybercrimes Division of the JCF. And I have Ms. Alana Wanlis from the Legal Services Branch within the JCF as well. So that is the cohort that we have represented here today, Chairman. The ministry is seized with the importance of the cybercrime and the threat it presents to national security. So this is a welcomed opportunity to be able to make a presentation to the committee. And I hasten to highlight that our recommendations were developed in collaboration with our partners in the JCF, who interface directly with the legislation as a part of their function. This is a brief overview of the presentation. We're going to discuss a little bit about the global perspective, then the local situation, and move into our specific recommendations, and then facilitate any questions that the committee may have. I know I'm preaching to the converted here, but just to reinforce cybercrime as a global concern, we took this quote from an article released by Interpol in August 2020, highlighting that cyber attacks increased at an alarming rate during the COVID-19 pandemic, as cyber criminals sought to exploit the fear and uncertainty that it brought with it. These news clippings were taken from the internet just this week as examples of very recent and major cyber attacks. And you will notice that these touched on 4 major sectors. Those being food production, with the attack on the J-Base meatpacking plant in Colorado, US, which resulted in a total shutdown of its operation last Sunday, following a ransomware attack on its headquarters in Brazil. Now, this company accounts for 20% of the beef production in the US market, and the attack not only affected the operations in the US, but also in other territories, such as Australia. And they were just able to resume normal operations yesterday. In the energy sector, we saw the cyber attack on the Colonial Pipeline, which represents one of the largest fuel pipelines in the US, and suffered a 6-day shutdown in May, which is really another case of ransomware that was deployed on their systems. AXA is a French multinational insurance giant, and Waikato, the district health board in New Zealand, both suffered ransomware attacks as well. Waikato being severely affected because a lot of their servers were shut down and they were unable to deploy critical health services such as major surgeries, and patient data could have been compromised. Now, as we speak at this moment, they're still working to restore the services that were affected by these attacks. So we really see here the extent to which cybercrime is affecting partners around the world in a severe way. We also looked at an assessment that was undertaken by Interpol, still in 2020, and the assessment highlighted 5 focus areas that countries should consider to effectively combat cyber threats: online scams and phishing, disruptive malware or distributed denial of service attacks, vulnerability of remote workforce, malicious domains, and misinformation. The assessment was completed using a survey instrument and based on responses from member countries. The graph here illustrates the distribution of key COVID-19 inflicted cyber threats that were identified. Malicious domain flagged in 22% of the responses, ransomware 36%, phishing and fraud schemes 59%, and fake news 14%. So resources like these help to kind of hone our perspective in how we undertook the review of the cybercrime legislation and the local context in Jamaica, based on what we see happening around the world. Now, other important information to note: malicious domain, as noted in the report, between February and March of 2020, recorded a 569% increase, including malware and phishing, and 788% growth in high-risk registrations based on information that law enforcement entities would have gathered around the world. Ransomware or denial of service attacks. In the first 2 weeks of April 2020, right after COVID broke out, there was a spike in ransomware attacks, and multiple threat groups who were formerly dormant reactivated their activities, reactivated themselves, and started to deploy attacks on entities around the globe. With respect to online scams and phishing, about 2/3 of the member countries reported significant increases in this area as cybercriminals increased their deployment of COVID-19 themed phishing emails, often impersonating government and health authorities to entice victims to either share personal data or download malicious content. Now, with respect to misinformation, this is nothing new based on the prevalence in the news media. Unverified information, inadequately understood threats, and conspiracy theories have contributed to anxiety in communities and in some cases facilitated the execution of cyber attacks. Nearly 30% of the respondents to the survey indicated that they saw a spike within their countries after the COVID-19. So within the Jamaican context, we obtained statistics on the court cases, cybercrime court cases that were brought to the court over the period 2017 to 2020. Now, in studying the data, we identified some recommendations that could improve data collection for future analysis. But the major takeaways from the information as presented is that over the period, unauthorized access to computer data and computer systems and the use of computers for malicious communication comprise the more commonly prosecuted offenses. By and large, we saw where these featured in a major way consistently over the 4-year period. As you will note in the ministry's submission as well, a total of 141 cases, this is generally across all cybercrime cases, were disposed over that 4-year period. We only had the breakdown in terms of convictions for 2017 and 2018. So we're still working with our partners to refine the data, to really improve the analysis of this situation within our legal and regulatory framework. So here we've consolidated the offenses based on the data that we have. And this is really just to reinforce the point that unauthorized access to computer data and use of computers for malicious communication comprised the larger numbers in terms of the offenses brought before the court. So we also obtained some data from the JCF Communications Forensics and Cybercrime Division, because we can well appreciate that cases brought before the court is different from cases that would have been reported to the police. Not all cases actually make it to court based on either the quality of the information or perhaps the inadequacy in the report may just not substantiate the offense. In respect to the period 2018 to 2020, what we see is a consistency in malicious communication and unauthorized access being the majority of the cases, but in the inverse, where malicious communication is reported more frequently than unauthorized access. So at least we can identify that within our population, these two areas in cybercrimes are being featured in a major way, but still without improving the data, Chairman and committee members, there is still room for deeper analysis to understand what's really happening at a local level. So some deductions that we drew based on this data. Cybercrimes are being underreported. Over the 4-year period, 2017 to 2020, was approximately 245 offenses, give or take a few. And this is also confirmed by law enforcement that cybercrimes are being underreported. We saw where standardization of how the data is collected would significantly improve our understanding of the local situation. And we found that against global trends, our legislation did not necessarily provide for new forms of cybercrime. So we weren't really able to get a true picture of what's happening within the context of cybercrimes within our local context against global trends. So this is an area that the ministry has identified to target in collaboration with our partners over the medium term. Importantly, the gap that was observed in respect of new offenses formed the basis of the recommendations being put before the committee today. So now, Chairman, I'm going to move into our proposed amendments. And the first recommendation that we're putting to the committee is to amend Section 9, subsection 1, which treats with the use of computer for malicious communication, to include data of a particularly graphic nature, such as violent events resulting in death or serious injury or the maiming of a person or persons, which may be grossly offensive or could cause psychological harm to a person. We've observed that members of the public have grown insensitive to the possible impact of certain content being transmitted via digital platforms. Data comprising graphic content are often circulated with circumstances leading to death and other forms of misadventure that is really gross in nature without due consideration of how it may affect the recipients, sometimes being children or close relatives. And so these persons would not have an opportunity to absorb the shock brought on by these incidents. Admittedly, committee, we did debate a bit about this recommendation, but we thought it useful to include it just to do a temperature test of the committee to see what kind of feedback we got on this recommendation. But this is really an emerging trend in our society and is a significant problem if ignored. Our next recommendation, committee, under section 20, that treats with forfeiture, subsection 1, it's been proposed that where reference is made here to section 19, which provides for the record of seized material, that this be changed to section 18, which empowers the parish judge to issue a warrant to a constable to search for and seize computer material. The proposed amendment would link the provision in this section to the specific provision in the Act where the authority for granting the warrant resides. Still under section 20, subsections 2, 3, 5, and 6, we propose to the committee that the power conferred upon the Director of Public Prosecutions be broadened to include the Clerk of Courts to facilitate easier administration of these matters in the court system. We know that this recommendation was also made by the major organized crime and anti-corruption agency, and I'm sure we'll do a lot in terms of easing the administrative processes in court. Moving on to section 21 that treats with production orders, subsection 1, it is being proposed that the section be amended to empower a constable to make an application for a production order that requires a person to produce any key used to access the data or computer output that is already in the possession of the constable. This would have been otherwise obtained throughout the investigation, such as during a search and seizure operations. In instances where the police are already in possession of the data or computer output, an ancillary order would be required for that key to be produced. But such an order is dependent on first having obtained a production order for the data or the computer output. In this case, that data or computer output is now in possession of the police. Similarly, in cases where the police would have already obtained a production order, a second application would need to be made for obtaining the key using an ancillary order. So the proposed amendment would simplify the process by including both considerations in a single order and eliminate the duality in the situations described. In order not to lose the effect of the ancillary order as captured in subsection 8, the police would still need to meet the same criteria established for obtaining ancillary orders, but would now be able to make a single application for this provision. That concludes our recommendations for amendments to the existing provisions. So now we're going to move into our recommendations for new offenses under the Act. First offense that is being proposed to the committee is to make it an offense to disclose a key in respect of a protected computer to a person who is not authorized to receive that key. It was noted in our review of the Act that the provision contained in section 10, subsection 1, establishes an offense for disclosing a key, but only in circumstances where the disclosure is done for the purpose of committing or facilitating the commission of an offense. It is being proposed that the mere act of disclosing the key, but only in respect of a protected computer, as defined by section 11 of the Act, be considered an offense. And this should be immaterial as to whether the disclosure can be proven to have been made for the purpose of committing or facilitating the commission of an offense. And this is based on the implications of the computer systems defined by the Act. As the members will note in our written submission, we included references from legislation in other territories that we would have consulted during our review, and we included the language just to demonstrate the spirit of the recommendation as reflected in other pieces of law from other territories. So I won't detain the committee with going through these provisions, as I know you have copies of them before you. We also included some local examples of each of the offense that we're proposing, just to highlight that these things do happen and have attracted media attention in significant ways in the past. So in this example, we have a Gleaner article where the Post and Telecoms division asserted that unscrupulous employees within the banking systems were assisting criminals to activate stolen debit and credit cards by providing personal information and information on the key for those cards that were issued. And this article was followed by the discontinuation of using the Post and Telecom by some banking institutions. The next recommendation to the committee deals with false publications. We propose the inclusion of a provision that makes it an offense to deliberately make a false publication over a digital platform with the intent to commit or facilitate the commission of an offense. False publications have led to misinformation, outrage through deception, incitement of violence, and in some instances, physical, financial, and/or reputational damage. I recall from the last meeting of this committee, there was a very robust debate about the reputational damage that can be caused by misinformation spread via digital platforms and the lack of appropriate redress to the victims of this kind of activity. So we believe the inclusion of this specific provision would assist with that kind of situation. And again, we've included verbiage from other pieces of legislation just to introduce the spirit of the recommendation as captured in laws in other territories. This particular verbiage was taken from the Computer Misuse and Cybercrimes Act 2018 of the Republic of Kenya. And what we tried to do in our review is to restrain ourselves to legislation that was passed after 2015, just to determine what observable differences there might be in our law, as also if there is any more modern provisions that may have been omitted from our legislation. Again, another sample of false publication and local examples that follow the COVID-19 pandemic. In March last year, there was fake news about an impending lockdown in Westmoreland due to the COVID-19 virus resulted in panic, and the JSAF would have advised the public to refrain from spreading false information about the pandemic. Similarly, the Prime Minister also uses Twitter account to encourage citizens to desist from causing chaos and panic through the distribution of false information about the pandemic. Our third new recommendation to the committee deals with cyber squatting or cloning, and it is being proposed that this offense be included to treat with the unauthorized use of intellectual property in cyberspace. This, I believe, is timely based on the conclusion of the bill to amend the Trademark Act and the impending accession to the Madrid Protocol. Again, we've included verbiage. This particular example is taken from the Cybercrimes Prohibition and Prevention Act of 2015 in Nigeria. And a local example that we've included, popular reggae artist Christopher Martin would have suffered from online scams of this nature, where persons deployed phishing emails and lured customers to pay monies for booking and other sorts of offerings that would have been included under his brand. Another example, which happened actually last month, local fitness enthusiast and Instagram personality, Shani Fitness, her Instagram account was hacked. And it took her 2.5 weeks to regain access to her account. And I took some quotes from her video, which I think connects with the ordinary folk, because sometimes we think that we are far away from being a victim of cyber crime. So in her video, she noted that few of you know that her Instagram account was hacked, and it was the first time in her life that something like that ever happened to her. So we hear about these things, and it seems so far-fetched. She got a notification that communicated she would have been in violation of Instagram policies, and it prompted her to enter her username and password, and that gave access to her account. The hacker was able to change her information, bar her from accessing her details, and she could not communicate with Instagram through any legitimate means because she no longer had access to her account. So it was out of a outcry on social media that her situation got some attention, and she eventually got redress, but 2.5 weeks after. And in her rant, as she called it, there was no mention of reporting this to the police, which underscores the point that we have victims within our population that may be unaware of the avenues for getting redress, or just not motivated to utilize the formal channels to investigate or assist with these issues. So this again reinforces the point that cyber crimes very much occurring and not being reported as we would want them to. The next recommendation to the committee is to establish the offense of phishing. And phishing attacks have increased by 1,000% in the last 5 years, according to the FBI, and was the most common cybercrime in 2020. Some sources estimate a single phishing attack to cost companies to the tune of US $1.6 million. There was a survey that I was reviewing, Sophos survey, that noted that the average cost of ransomware and phishing scams have doubled since the COVID-19 pandemic. Prior to COVID, it was estimated in the region of 700,000+ US dollars, and this has doubled since the pandemic has hit. Jamaica has not been spared. As you'll note on the next slide, we have local examples of phishing attacks. In 2019, NCB noted that some of the company's customers had fallen prey to phishing emails, resulting in customers providing personal data and passwords to criminal elements. And so the bank had to undertake a drive to sensitize and educate its customer base so that they reduce these instances. I'm sure some of us may have received these kinds of emails in our personal accounts, either seeking to lure us to be victims of phishing, or from the bank advising us of phishing and warning us against phishing schemes. Our next recommendation to the committee is to establish an offense in this act for cyber terrorism, a case that I believe is well made. Terrorism is a tier 2 threat in our national security policy, which means that there is a low probability, but a very high impact potentially if it ought to occur. Most of us may have heard the Caribbean region discussed as a soft target within the context of terrorism, and a place where organizations often recruit members. So this is a very important provision, as terrorists now move more of their activities online. In this example, we have a Singaporean national, a 16-year-old who was radicalized through the internet. He would have seen content produced by ISIS and took it on to the extent that he started to plot attacks on mosques and was detained locally, and this was intercepted. So I think that it would be very important for our legislation to have this provision in there in the event that there is any eventuality along these lines within our territory. Our final recommendation from our submission is to establish an offense for intentionally withholding a message that is erroneously delivered. And we have included verbiage here from the Kenya legislation. A person who intentionally hides or detains an electronic mail, message, electronic payment, credit or debit card, which was found by the person or delivered to the person in error, which ought to have been delivered to another person, commits an offense. And this is something that happens in our society very, very often. We actually received numerous examples from the JCF, CFCED, where persons would have been victims of this offense with a limited range of options for redress. So it is against this background that we are making this recommendation to the committee. Now, this would have concluded the initial recommendations made in our submission, but we thought it useful to include 2 additional recommendations. If the committee is minded to consider them, we could always update our submission and resubmit. We would like to propose to the committee for consideration the inclusion of a provision that empowers the minister to amend monetary penalties by order, subject to affirmative resolution. This is in keeping with the development of modern legislation. This would make the legislation more nimble based on the rate at which cyber offenses are created or increased in deployment. In the event that we find ourselves with a provision that is no longer a deterrent, the Act ought to empower this kind of revision in a more nimble and agile manner. And so this is the basis on which we're making this recommendation to the committee. Finally, law enforcement would have shared with us that traditional major crimes now feature on a regular basis, almost in all cases, a cyber element. And so we thought it useful to raise for discussion and consideration here the inclusion of a schedule that establishes reference to other major pieces of legislation, major offenses that would have featured the use of a digital device. For example, a murder may have been a consequence of an instruction via some technology medium, or devices may have been used to transmit messages to lure persons to abduction and other forms of major offenses. We weren't able to find examples of this in other territories, but we could develop on this in terms of the issue that is being faced by law enforcement and include this as a amended submission if the committee is so minded. So at this point, Chairman, I want to thank the members for listening. I know that members may have been noting questions, so I avail myself now, the team here, to take any questions that the members may have.
Thank you very much. Very good presentation. Very, very thorough presentation with very, very valid points. Let me open up the floor to membership for any questions or comments from the presentation made by the Minister of National Security.
Chairman, may I?
Go right ahead.
Very good presentation, interesting. And I want to start, Chairman, from one of the last set of proposals, not amended proposals, but new proposals. And the one that jumped out at me was regarding intentionally withholding message or delivered erroneously. So as a person who intentionally hides or detains any electronic mail, message, electronic payment, credit or debit card, which was found or delivered to the person in error, which ought to be delivered to another person, commits an offense. Now, the first question I want to ask is, what is the expectation of the recipient? Because in this instance, you have email that may have been sent, which would have been recalled by the sender. I assume that this might also include if someone sends a little credit to someone, so another person's phone, which was not the intended recipient. Does this also pose as an offense? And in these situations, what would be the proposed penalty in this regard? That's the first question I want to ask. The second question is in relation to the reporting of attacks. And I note where the incident report has been extremely low. And so this hinders case submissions. What are some of those factors that could improve that? And the next question in relation to that, I'd want to ask if whether or not financial institutions who their customers come under attack, if they just internally do their own investigation, or are these incidents reported? So, Chair, I have some more, but I want to start with those two.
Thank you, member. And I'm going to respond to the questions in reverse order.
But all of a sudden, you're going on a little low again.
Is that okay?
Much better now, because I want to hear you, you know.
Hold on, let me.
Yeah, man, you're good now. You're good now.
Good, you sound good. Go right ahead.
All right, so in reverse. So the question about the financial institution, very interesting question, because this is actually an issue that is shared among the vast majority of countries. You will appreciate that financial institutions are particularly cautious about news that could negatively impact their reputation. And so this inspires an unwillingness to report these things. So the preference is to deal with them internally. So you will find a customer making a report, but only in cases where they are unable to get redress, having reported it to the financial institution. So I can tell you that the financial institutions invest a lot of money in employing talent and putting things in place to make their security and investigative capacity robust to be able to respond to these reports. In other discussions, it has been thrown around the idea of making it mandatory for institutions to report these things so that it can be brought to the attention of law enforcement and provide a true picture of the activity within this space. So I hope that responds to your question. I think to add to that, I would say that it's a matter that is being looked at the policy level, but no definitive position has been taken. So outside of education campaigns to encourage consumers to report it and encouraging institutions to report it, there really is no, there's no requirement that can be brought to bear on these institutions or consumers to bring it to the attention of law enforcement. The other question.
Yeah, no, before you go to the other question, and there's no encouragement at this time to make it mandatory.
Let me not, well, I don't want to say that there's no encouragement. There is consideration. It is being explored to the extent that it can be made mandatory.
Okay, all right.
Mr. Chairman, Julian Robinson, could I just intervene on this point? What you're talking about was the subject of a lot of deliberation when we did the amendments to the Act in 2015 about whether you make it mandatory for businesses to report incidents. And we spent a long time deliberating it, and we ended up not doing it. And I'll indicate why. The first thing is that we felt that if you force them to do it, they definitely wouldn't. And you didn't have the capacity to determine whether an incident took place or not. And what you wanted to do was to build and develop a relationship with them where they felt it was in their interests to report it to you so that you could help their business to recover from it. But if you make it mandatory and an offense, and you have no capacity to determine whether an incident actually takes place, because technologically you can go into their systems to know if there's a breach, then you're not going to get the cooperation that you want. You want to get to a point where they see it as being in their best interest to work with the CERT and the authorities to report on issues so that you can strengthen your collective cybersecurity rather than taking what I might call the punitive side, which is to seek to punish. So I'm just sharing that. I'm not saying that you have to stay there, but that was something which we considered significantly when we did the first set of amendments in 2015.
Julian, if I may, and Chairman, permit me, I beg you. The question arose in terms of seeking to catch the known perpetrators. Yeah, that there's a follow through rather than the business just deal with it and satisfy the needs of the customers. You still have the situations where the known perpetrators are out there. And that was why that particular interest may have arisen.
Mm-hmm.
Yeah.
Mr.
But I can understand where that committee would have had deliberations on the matter.
If I may come in. Frank, I beg you for a second. When we were, and Julian would remember, when we were doing the Cybercrimes Act, we had a difficult decision to decide on which limb does the law fall. Does the law fall on the limb of the customer or the business? Now, as government, I think that our duty is to always seek to protect the customer, who in many cases is the most vulnerable of the equation. You said that previous deliberations before I was here, we fell on the side of business based on the realities that many businesses would not necessarily voluntarily offer information. But the question is, we have had several cyber attacks on businesses which have impacted customers, and a system where businesses seek to, for their own reasons, solve the problem internally, does not send a message and does not hold those who consistently impact the customer in a negative way accountable. So I listened to the presentation and I found it quite interesting, but the question I want to ask the committee is, do we fall on the side of the business, or do we put the interest of the customer, the citizen, prominent? I personally believe, Julian, that we should try as much as possible to protect the interests of the customer, even if the customer is not, on the face of it, a customer of a particular institution. But generally, how do we protect the customer when the institution is looking out for its own corporate interest, while other customers tend to be impacted by these persons who, based on the actions of the business, are allowed to continue their actions?
Well, all right. I wouldn't use the way you framed it, Nesta, as being on the side of business versus consumer, because ultimately you want to get to the perpetrators. Let's just look at what is happening right now with JBS, the largest beef producer, who is now the subject of a ransomware attack, and that has caused a whole lot of things in the meat market. Now, there is going to be a response from the authorities, and in this case, the US authorities, and they will probably respond by a commensurate attack on Russia, where they believe the thing is coming from. Really, the question is, do you want to put an offense on the part of the business and you don't have the capacity to determine whether an offense really took place? What is really the point, right? Versus trying to build a relationship of collaboration where they will believe that you have their interest at heart and your intervention to protect not just their business, but also to protect consumers.
But Julian,
so it's not that I'm coming down on the side of
Mr. Chair.
Go ahead. Go ahead. Who's that? Senator Gill?
Mr. Chairman.
No, Chair. I'm still awaiting
Chair,
the response to my second.
MP Witter, sir. MP Witter.
Hold on 1 second.
MP Witter.
Yeah, MP Witter. Hold on a second for me, because we started with Senator Gill, and we had two interjections from.
Yes, I'm on the same point.
So I want, okay, so go ahead, MP Witter, and then we go back to Senator Gill.
Yes, I want to support the point made by MP Robinson, in that my question is, at what point will the police be able to prosecute in terms of determining whether for example, a transfer would have been made to someone's account, the person withheld? At what point would the police be able to prosecute by determining whether this transfer would have been made involuntarily or not? And that is my big question for the presenter, as to at what point will the police be able to prosecute?
Soup Williams here. Can I respond specifically?
Yeah, go ahead,
to Mr. Robinson's response. Based on what we are seeing, it's kind of difficult to, invoke a prosecution, in the sense that most of the times the banks or persons being victims, the only time it's reported to the police if they're not getting the cooperation from the institution in terms of if there's a loss and the bank or institution may be taking a while to reimburse, then it comes to the attention of the police. But 9 out of 10 times, the institution reimburse the person in a reasonable time. Because the argument by the institution is that insurance covers the loss, so the victim doesn't have to worry. They do their internal investigation and reimburse the persons. We're only concerned about the data in terms of the frequency of these offenses, attacks or breaches, which will inform us to better prepare ourselves strategically of how to deal with these incidents, because they could be ransomware, they could be unauthorized access. The police is interested in collecting that data, which will inform us, prepare ourselves in terms of investigative support and how do we deal with cases like these.
But Mr. Chair, and I must apologize for interjecting. The purpose of the law is to act as not just punishment, but also deterrence. So the question I want to ask is if the current system maintains itself where institutions for their own corporate interests do not report the incidents because they feel that would damage their corporate image, and you have criminals continuing to perpetrate these acts, not just against these institutions. They may perpetrate it against an institution in an instant, but they may also extend their activities to the wider public. And you do not have the benefit of that situation with the corporate entity. And then that person now goes on to perpetrate it against another because the corporate entity does not make you aware that this incident took place and that we have evidence that they are the ones who did it. How do we as legislators contemplate and accept that sort of situation? I would want to feel that we will have an amendment that will ensure that wherever there is an infraction or an offense that takes place, that the constituted authorities are empowered to act to ensure that there's a deterrence so that the individual or individuals who perpetrate this offense can be held to book. Is it a case where we are saying that the intricacies of the situation is so much that we may not be able to do it?
Member Longmore, can you mute for me, please?
Oh, sorry.
You're coming in?
Not sure. Is there a response to MP Morgan's comments?
Waiting on that now. Yeah, so let's get that. Okay.
If I may come in here, Chairman, I would like to say points are well taken, and these are some of the nuances that we seek to work through. The points made by Member Morgan is very valid in terms of the purpose of the law being a deterrent and also being an avenue for protection for consumers ultimately. But the point made by Member Robinson is also valid in terms of not being able to tell when these incidents occur. But the truth is, you would want to be empowered to be able to act when you come into the knowledge that these incidents have occurred. And so institutions could be made through legislation to have that responsibility to make that report. And if they fail to comply, they would understand that they're operating in breach of the law. That being said, the policy debate and the research continues. I will also share that we have engaged entities from the financial sector through another effort to review the national cyber strategy, and there is a overwhelming level of support for initiatives that will improve cybersecurity within the country. So that partnership is being built, and work would have already been done prior. And I think that the interest is there, but I do take the points being put forward by the committee, particularly, where does the law fall? Is it in the interest of the consumer or the interest of the institution?
The only thing I would ask you before I leave and allow my colleagues, and I must apologize to my colleagues, is
railroading.
What is the international? My apologies, sir. I suspect you'll be able to negotiate a proper settlement after I finish speaking. What is the international standard in relation to this particular issue?
The practice is collaboration, working with the sectors to strengthen this area, but there really is very little example of where it's mandatory.
Which is why I think that's why we took the position we did in 2015 when we looked globally at what other legislation existed, and we didn't make it mandatory. And what it requires, frankly, is a partnership where the private sector views the CERT and the national capabilities as being in their interests for collaboration. So when they have an incident, even if it's not made publicly, they will report to the CERT and say, XYZ happened, can you assist me in dealing with the person? So it doesn't mean that you won't get prosecutions. You can still get prosecutions, actually, but you stand a much better chance of getting to your perpetrators via collaboration versus making it mandatory via legislation. And apart from maybe Israel and the US, I don't think we will develop the kind of capability that we would know what happens in a bank without the bank telling us, if you understand what I mean, And I think we will, just by virtue of our size, we will always be catching up. And so I believe collaboration should be the preferred way forward. And there are ways to strengthen that collaboration so that entity seat has been in their interest to share information.
Chairman, I know my first question would have created a debate, sir. I hope Mr. Morgan can now respond to the question of intentionally withholding the messages delivered in terms of his proposal, where I'd ask what would be the expected response from the recipient, and if it's a breach that is being committed, what would have been the proposed penalty?
Thank you, member. So the expectation is that the member will comply and return or delete or otherwise destroy anything that is erroneously delivered. In terms of a penalty, we did not undertake a specific recommendation of the penalty. Certainly, our recommendation would be something that is proportionate to the nature of the offense. But
so you're saying, therefore, that the proposal for the legislation is in order to bring clarity in terms of the action of the recipient, is that they must either delete or send back or something like that, but declare the action that is required.
That is correct.
Okay, thank you.
You're welcome, member.
Thanks, Chair.
Chairman, if I may.
Yes, Dr. Senator, the Honorable Longmore.
You're adding something else, sir. All right. Good afternoon, and thank you, Mr. Morgan, and your team from the Ministry of National Security. A very comprehensive and insightful presentation. I have a few, just maybe stemmed around one particular issue for me, particular because of my personal background, of course. You mentioned in the beginning of your slide, you reflected some of the cyber crimes that we're seeing, particularly with ransomware, malware, phishing, etc., and DDoS. I wondered around SQL injection and local file injection. My main concern around this is because of the propensity for these to happen in the healthcare industry. And a lot of research is coming out. It is reflected that actually the healthcare industry, second to the financial industry, is the one that is most under attack by cybercrimes right now. And with our push towards integrated health systems and the propensity towards insurance fraud, et cetera, I'm wondering if you have any reflection on that and what any recommendations around that, and particularly, like I said, around the SQL injections that tends to be quite hidden and quite it is what is apparently the rising risk that is now being seen. Thank you. I have just one other comment around your recommendation around 9.1, but I can wait until you respond. Thank you.
All right, in response to that question, basically, I would see it falling under unauthorized access. Whatever SQL injection, once you access software or computer systems, if you do not have authorization to access the system, then it's a clear breach and an offense. So that is pretty much already covered into the act. And we could go more granular with specific offenses, but the broader umbrella terms of...
If I may, what I was wondering was whether or not, just like how you presented on what we have seen as examples here, have we had any such circumstances to your knowledge? And if not, just also recognize that this is one of the most increasing methods that are being used.
We can't definitively say because, as the presenter said, a lot of these offenses are underreported. Most of what we're seeing is ransomware, and most times the affected victim, they take corrective action without allowing the police to do their investigation and analysis. So we can't definitively say that that is taking place.
And herein lies one of my main concern, because of course you can understand the vulnerability of, it's a double whammy, and it ties into with what Senator Gale initially raised, and it has a particular predisposition in the healthcare industry in terms of the consumer versus the institution. So that is why I'm really very concerned about it, because in those circumstances, that is where the underreporting tends to be quite significant, and the damage could go really very far reaching, to the point where persons could be wiped clean of their insurance access. So, you know, I'm just trying to hear, it is a very evolving field, and I'm just trying to hear if you have any insight that you could shed on that.
Well, again, I want to emphasize what Member Robertson says. It's a collaborative effort in the sense that once the industry is affected, it means that they need to bring this to light with the law enforcement and the legislators so that, you know, we can have a deeper look into what is happening and how best to treat it. Okay, thank you. Well, I will hope that we have extended the invitations to the relevant persons, so I hope that we can get that. Just one other comment regarding your recommendation at 9.1, including the particular sharing of graphic imagery and so forth. I definitely would endorse that. I think it will be a little bit difficult to monitor and control. I'm not sure, but I definitely clearly would recognize that there is significant psychological impact that can happen in those areas. So I'm very supportive of that consideration. Thank you, Chair.
Thank you, members. Very interesting questions and commentary. I think we can safely thank the Ministry of National Security and move on to the next presentation, which will be the Officer Director of Public Prosecution. Can we invite them to make their presentation introduce themselves and proceed. Thank you.
Thank you, Chairman. Thank you, members.
Thank you very much. Good afternoon, everyone. In terms of introductions, I am Andrea Martin Swebe, Deputy Director of Public Prosecutions, and I'm also the head of the Cybercrimes and Digital Forensics Unit at the Office of the DPP. Today, I will be presenting along with Mr. Orrit Brown, who is also a Deputy Director of Public Prosecutions, and he is the Deputy in charge of the Cybercrimes Unit. And I just wish to acknowledge that the director herself, Ms. Paula Llewellyn, is also on the platform, though she is muted at the moment and not using her video. So in terms of the presentation, I will be dealing with the issue of how the cyber matters have been managed in the criminal courts, dealing with the issue of sentences that have been imposed, and seeking to share with the Joint Select Committee pretty much an understanding of what takes place once the matter goes before the court and is within the court processes. Secondly, I will highlight some of the cyber matters that have attracted the public's interest, and also assess how we have used particular sections under the legislation in bringing matters before the court. Then I wish to look at the recommendations. The first recommendation that the Office of the DPP will be making is that all cyber crimes or cyber offenses are fingerprintable. And I will go into the legislative structure as it stands now, and then seek to justify that recommendation. Then we will also look at the malicious communication section, and that will be dealt with by my colleague, Mr. Orrit Brown, as we are recommending a complete overhaul of that section. And we believe that it is important for the revenge pornography, violation of privacy type offense to be given its own particular section, and that is in keeping with the different legislations that we have looked at, particularly the UK. They have passed legislation that treats with that by itself. Canada, New Zealand, I think Australia as well, but that is what Mr. Brown is going to look at. So I'll just head into the presentation. Now, the Office of the DPP submits that the Cybercrime Act represents a critical legislative instrument in our legislative structure as a whole, as it gives law enforcement, one, apart from the offenses that are named under the legislation, it gives law enforcement the tools that are needed where they embark on any criminal investigation that involves the gathering of digital evidence. So as Mr. Morgan had alluded to, the production orders, there are also search and seizure warrants, there are also preservation notices that are allowed under the legislation, where an officer can seek to use either of these tools to enhance any criminal investigation. Our legislation pretty much fashions the Budapest Convention of 2001. And we recommend that even where there's a review of the legislation, that the basic offenses that are contained under the Budapest Convention continue to exist. And I do recall that the Council of Europe indicated that the Budapest Convention really represented the base or the skeleton, or the bare minimum that the cybercrime legislations ought to address. And we have in fact addressed all of that. In respect now of how our legislation has been utilized within the court system, we had prepared written submissions which were submitted to Parliament, and we had included statistics for the period of 2017 to 2020. Now, when we look at these statistics, and I trust that the committee members have a copy of the submissions, if not, I'll try my very best to go through in as much detail as I can. Now, in 2017, there were 97 cybercrime matters before the court system. These statistics primarily speak to the matters that are before the parish court. And I'm going to delve a little bit more deeply as I go into the presentation as to why it is that we elect to have most of our cyber matters remain in the parish courts. Perhaps I could say at this stage that the legislation allows for dual jurisdiction. So the matters can be tried in the parish courts as well as the circuit court. But if the matters are committed to the circuit, it would involve a trial by judge and jury. Now, this sometimes and in many instances is a bit of a concern for us as prosecutors. Whereas, or I shouldn't say whereas, digital evidence is not the easiest concept to grasp. It's not the easiest concept to grasp for practitioners, as in attorneys, for judges, more so for members of the public. So if it is that to bring a matter to the circuit court would require a jury trial, it means that the difficult technical evidence will have to be understood, not just by the attorneys representing the Crown and the defense, but by the judges, and then also 7 laymen that are taken to and empaneled to try the particular matter. Also, it is our view that perhaps Parliament could contemplate that where we have the dual jurisdiction and matters are tried in the parish court and in the High Court, that when they're tried in the High Court, they are tried by judge alone. This is the pattern that has recently been evolving. So our human trafficking matters are tried in the High Court without a jury. All lotto scamming matters, the law reform fraudulent transaction matters are tried in the High Court without a jury. All the anti-gang matters are tried in the High Court without a jury. So my submission is this: if Parliament sees it fit or is of the view that a parish court sitting alone can appreciate and adjudicate over a cyber matter, why not a High Court judge? What is the benefit to a cyber matter being tried by a judge alone in the High Court? 1, matters that are tried by judge alone tend to go through the system a little quicker than matters that require a jury. In fact, because of the pandemic, the matters that are primarily being tried in the High Court are the judge alone matters. Where you have to concern yourself with a jury, 1, in a cyber matter, you have to concern yourself with having a panel that can appreciate digital evidence and the technicalities associated with it. But also, we have always had a jury problem in Jamaica. And so therefore, it is my submission that Parliament ought to contemplate adjusting the Cyber Act so that where the matters are tried in the High Court, they're tried by judge alone, similar to your human trafficking, anti-gang, all gun court offenses, lotto scamming, and all of those offenses. So for the moment, the matters primarily remain in the parish court with the hope, and I say hope, that it goes a little more smoothly through the system. But the parish court itself suffers from a tremendous backlog as well. And so if we look at the statistics, we had 97 matters in the parish court in 2017. And in terms of disposal, there were 23 matters disposed of that year. In 2018, we had 75 matters before the court, and the disposal rate again was pretty low. It was 10 matters in 2018. In respect of 2019, there were a total of 39 new cases. With those that were carried over and the new cases, there were 75 that were disposed of, leaving 45. So there was a bit of an increase or improvement in the disposal rate. In the year 2020, we had 83 new cases, 103 were disposed of, and 107 were pending. When we look at the statistics, and I will not repeat what Mr. Morgan had said, I agree with him that primarily the matters are brought under Section 3, which is unauthorized access. There are few matters brought under Section 4, which is access with intent to commit an offense. And then you also have a healthy number of matters brought under Section 9 for malicious communication. So the legislation is being utilized within the courts. And I think we should commend our police officers, certainly for the investigations that are conducted, and also in respect of how, or primarily our clerk of the courts and the office of the DPP seek to manage the matters through the court system. I recall that when the legislation was reviewed in 2015, and the panel members can correct me, but the penalties were increased for most of the sections. Though the penalties have been increased, what we see is that the sentences that have been imposed are primarily fines. And in terms of the terms of imprisonment, I don't think we've had a term of imprisonment that is more than 2 years. And I'm going to deal with that because I know a lot of times in Jamaica, people say, why are the sentences so low? And though I'm not a judge, and we are not judges from the office of the DPP, but we can take the panel through what happens during a sentence hearing and what may account for those reductions. Firstly, I must say this. I believe it's important for the Joint Select to look at the sentences under the Cybercrime Act and, as I suppose, assess them against the sentences under the Law Reform Act, which is the Lotto Scamming Act, and the Proceeds of Crime Act. Under the Law Reform Act, the sentences range from 15 years, 20 years. Under the Proceeds of Crime Act for money laundering offenses, it's 20 years. And why am I using these legislation? I'm using these pieces of legislation because most cyber offenses have a financial element as well. And what we find in our courts is that where you have a lottery scamming matter, sometimes it's easy to add a count under the Cyber Act because the offenses are similar, or the offenses involve the use of technology, access devices, so you can pretty much elect which section or which legislation you go under. So if it is that someone is convicted under the Cyber Act, and those offenses, some of which are similar to your law reform, what accounts for the disparity in sentences? And that's something Joint Select can look at. When I look at Section 3, Section 4, pretty much all our integrity offenses under the Cyber Act, your unauthorized access, access with intent to commit an offense, unauthorized interception, unauthorized modification, all these offenses, the penalties in the parish court are 4 years imprisonment or a fine. And then when you go to the circuit, which is a higher court, it moves up marginally to 7 years. And I'm going to take an example of a case that was recently in the public's domain. The case of the NCB manager who pleaded guilty. If a plea of guilt is entered under Section 3 of the Cyber Act in the High Court, the judge starts at a maximum of 7 years. The effect of that is when you enter a plea of guilt, the judge, by virtue of the common law rules, must give should give a discount. I shouldn't say must, should give a discount. In fact, I would almost say the person is almost entitled to a discount. If you plea at the first opportunity, the maximum discount you can get is 50%. So you're starting at 7 years. If you enter a guilty plea, an early guilty plea, let us say you take off that 50%, that's 3.5 years. The judge must assess aggravating and mitigating factors. So if there are mitigating factors, such as it's your first offense, you're a person of previously good character, it's going to further reduce that 3.5 years. If the person pleads in the parish court, the maximum is 4 years. That's the starting point for the judge. So take off that 50%, you're at 2 years. Mitigating, aggravating, you may still settle at 1 year, 18 months, 1 year, 5 months. So that is something that I think Parliament ought to look carefully at. It's not just the penalty in the legislation, but also take in account how sentences are imposed, because sometimes it's a situation where the starting point already is relatively low, and the judge, in abiding by the principles of sentences, is almost backed in a corner, for want of a better terminology or phrase. So what you will see, even in terms of Andrea Gordon and the Queen, the lowest sentence that the judge imposed were the cyber offenses. For the cyber offenses, the judge imposed, and I have the authority is available online on the Supreme Court website. But just to be clear, the judge imposed 2 years and 11 months. It was the poker offenses, the money laundering offenses, for which the judge had imposed the highest sum, which was our highest term of imprisonment, which was 7 years. But remember, under the Proceeds of Crime Act, the judge's maximum is 20 years. For cyber, the judge's maximum is 7 years. So I think as a committee, you ought to assess carefully whether the sentences that are imposed under the Cyber Act reflect the severity of the offenses. Because in my view, the law reform offenses, the proceeds of crime offenses of money laundering are not anywhere more serious than the cyber offenses. I think these offenses are all in the same category in terms of the level of seriousness. So I just wanted to say that.
Andrea, before you go on, just on that point, I haven't looked through your paper, but have you given the number of prosecutions that have taken place since the updated act and what on average those sentences have been?
Yes, I did.
It is in your paper. Okay. All right.
Yes, I did, MP. So I looked at 6 cases. I have actually extracted 6 cases and I've looked at the sentences, and I'll take the committees through them. The first one was the case of Jiangping Zhang. It was a case of 3 Chinese nationals, and it had attracted a lot of publicity. 3 Chinese nationals that were held during a sting operation, and there were in excess of 400 credit cards, a number of electronic devices to include card writers and skimmers, and cash in the sum of $6 million that were seized from them. And they were actually apprehended outside of an ATM machine. They pleaded guilty and they were fined $250,000 or 6 months imprisonment. Under the money laundering, for the money laundering offenses, they were given a term of imprisonment of 9 years. Now, this particular matter had occurred, I believe, in 2016 or 2017. It was not before the passage of the new legislation. But as I said, the parish court judge who imposed that sentence had a ceiling of 4 years. Based on my recollection, because I had handled the matter, they pleaded at I think it was the earliest opportunity. I think it was on the second occasion that the matter was mentioned before the court. They had their attorneys and they pleaded guilty. So the learned parish court judge would have had to take that into account, would have had to apply a reduction and of up to 50%. And yes, the judge does not have to give the maximum 50. But in most cases, based on my experience, if you plead at the earliest opportunity, the judges are more likely to give you 50%. So what that does is it shaves it off to 2 years. If it is your first offense, or if it's, and it's not a, we consider it to be a I can't find the terminology now, but it's, the judge now is pretty much going down to nothing when the judge follows the principles of sentencing. And so I think that may have accounted for the judge opting to go for a fine, and the fine was $250,000, which wasn't really much. You had Umbrita Duffus and Alanda Howell. They also were after the passage of the 2015 Act. This was a scenario where the female defendant was actually a receptionist at a dental facility, and she had a skimming device, a cloning device. And several persons who had used the facility during that particular period noticed that monies were withdrawn from their accounts without their authorization. And that launched an investigation. Again, both persons were, a fine was in fact handed down for both persons. But thankfully, the FID were made aware of the conviction, and they did a benefit hearing, and the judge had imposed that $2.4 million in respect to the female defendant ought to be confiscated from her, and $500,000 from the male defendant based on the benefits from their offending. The matter of Tetlow Frith, Carlos Burton, and Jermaine Vernon was from the Manchester court, but it was really a matter under the old legislation, and the judge had imposed a fine. So I won't go into that one because it's the old legislation. For the malicious communication offenses, we have two that I have highlighted, one of which a term of imprisonment had been imposed. And the first matter was closer to the 2015 Act when the section was pretty new. It was a fine that was imposed, but I think I see where our tribunals are now beginning to consider seriously terms of imprisonment where there is this revenge porn, malicious communication scenario. So in the case of Donovan Powell, a term of imprisonment of 2 years was imposed at the parish court level, a fine of $1 million. But at the Court of Appeal, this sentence, the term of years was reduced to 1 year. And I want to say that perhaps why the Court of Appeal may have reduced it to 1 year is because of the ceiling that the parish court judge has, and then in sentencing you have to do that reduction where there's a guilty plea, and he pleaded guilty at a very early opportunity.
So can I just ask Mrs. Swaby, if what you're suggesting is to increase the penalty,
Yes.
and
Yes.
so to allow for early application of surrendering to guilt, then the judge would have a wider scope in which to treat with it.
Exactly.
Because
so.
when I'm looking at that 250,000 and where the penalty could have been just 500,000, then it's not much given the extent of the offense.
Yes.
And you're also saying to us to review the type of offenses and treat them differently in terms of a scale. In other words, if the offense is more egregious in nature, right, then the penalty should be able to fit that type of offense.
Well, what to put it another way, Mr. Gale, if you give the judge, I don't think the legislation needs to specify whether it's egregious or not. The truth is, if you give the judge a wider range to work with,
yes,
then the more egregious the judge can go towards the top of the scale.
So it's left up to the discretion of the judge in this case.
Exactly. But if you give me the room of only 4 years, you've pretty much limited my ability to be flexible. If I have, and my view is it's not just the flexibility of the tribunal, but I cannot see, when I've really assessed it, I cannot see why the penalties under POCA, the penalties under the law reform are in the range of 15, 20, but then the penalties under the cyber for the High Court judge is 7 years.
Again, just for my information. So the case that you spoke about a while ago, the recent one, was 34 million Jamaican, am I right? Somewhere around that?
Yes, Minister.
If it was 340 million Jamaican dollars, same?
Same.
My goodness.
Yes.
And then the parish judge would have had a ceiling of 4 years.
The moral to that, if you thief, you must thief big. I thought 34 was doing well, but I mean, I see, you understand, Senator Gale, the point I'm making?
I understand. That's the one with the malicious communication Ms. Swaby?
That's
No,
right,
no.
CB.
No.
I get you now. I get you now, Chair. I get you now. The
Yes.
most recent one.
Yes.
So definitively, that in itself speaks to the need for strengthening.
For strengthening and expanding.
Of course, absolutely.
Yes.
Absolutely.
Sorry, Minister. Yes.
Go ahead. Mhm.
Yes, Minister. So if you look at your section 3, section 4, all the penalties are pretty much similar under the Cyber Act. So in the parish court, and now I'm looking at section 4. In the parish court, whereas a first offense, a fine not exceeding 4 million or imprisonment for a term not exceeding 4 years. So regardless of the amount of money that is involved or the egregious nature of the act, the penalty here is 4 years. Mind you, I think the parish court judge, I think her ceiling may be 5 years. Mr. Brown can correct me, or I will do the research and submit at a later date. I don't know if it's 5 or 7 years. So the parish judge has a ceiling. But the high court, if the parish court is 4 years, now the high court judge should have a greater latitude. But for the high court, on conviction and indictment before a circuit court, it's 7 years is the starting point there for the first offense. So when the high court judge sits to even sentence for these cyber offenses, the high court judge has to bear in mind that she herself has to recognize the 7-year ceiling and then apply the sentencing principles. But it would have even been worse if it was the parish court judge, because there isn't that much room. It's less room to maneuver with. So I think the Joint Select may want to, in the review of the Cyber Act, look at certainly the penalties in the High Court for cyber offenses. They, in my view, should be similar to the penalties you see under the Lottery Scamming Act, the Law Reform Act, and the Proceeds of Crime Act. If we are saying that cyber offenses are just as serious as offenses committed under these other legislation. So if there are no more questions, I'll just move on right now because I notice it's also 3:45. So in terms of another recommendation, which I've outlined in detail in my submissions, all cyber offenses should be fingerprintable offenses. This issue came to my attention in about 2016, 2017, where a parish judge was on the verge of sentencing someone under the Cybercrimes Act. And the parish judge realized that she's a creature of statute. And so she looked at the Fingerprint Act to guide her in respect of whether she has the authority to order that a fingerprint be taken for a cyber offense. And she found that the legislation did not make cyber offenses, that's the Fingerprint Act, did not make cyber offenses fingerprintable. What is the potential problem with this? A high court judge has inherent jurisdiction. So a high court judge is not bound by the Fingerprint Act. A high court judge can impose an order for fingerprint. But most of our cyber acts or cyber offenses will remain in the parish courts. And if they're going to remain in the parish courts, these judges are creatures of statute. So if the statute does not say to them that they can order the fingerprint, then they do not have the statutory authority to do so. Now, there's a lacuna between that and even the very tone of the Cyber Act. Because what the Cyber Act says, if you look at the penalty sections, they say in the case of a second or subsequent offense under the Act, you may impose this fine or this term of imprisonment. That's what the Act says. So if the Act contemplates that if you do more than one offense or a second offender, third offender under the legislation should be treated differently, then it should be that the moment someone comes before the court for a cyber offense, a parish court judge should have the authority, statutory authority, to fingerprint that particular person. So I have outlined in my recommendations, that is in the written submission, why it is that I say the Fingerprint Act should be amended, or the new legislation that is passed should introduce a section which amends the Fingerprint Act. I think I see persons from the Legal Reform Department, so they would be more familiar with the semantics of how it is done. It is either you amend the Fingerprint Act under the schedule to include cyber offenses, or you insert in the cyber legislation that is passed that the Fingerprint Act is now amended to include all cybercrime offenses. Now, why I say this is important? It is important because the Fingerprint Act is the legislation that lists the offenses for which an accused person's prints may be taken. A judge cannot just say, I'm going to take anybody's prints. A parish judge can only take your print if it is that it's a fingerprintable offense, right? Now, the absence of this authority to fingerprint, it could lead to difficulties in respect of persons who are charged and convicted under the legislation. When you explore the Fingerprints Act, what is evident is that the legislation seeks to ensure that where a person is charged and convicted for a serious offense, that the court has the power to take and retain your fingerprint. It's important because also when judges seek to determine the issue of bail, the liberty of the subject, the judges now usually rely heavily on the antecedents of the particular person who is accused before them. The antecedents would only include all the offenses for which the person has been fingerprinted. So if it is that you can be charged for a cyber offense and escape being fingerprinted, it can cause problems as well in that scenario. And I hope everyone is understanding what I'm saying. We submit all cybercrime offenses are serious offenses, and therefore it is important that this also be included. Just as with all sexual offenses are fingerprintable offenses, when you look at the schedule under the Fingerprints Act, sexual offenses, law reform offenses, anti-gang matters, human trafficking, nothing regarding the cybercrime offenses. I think it may have been an oversight, and the truth is, it was when the judge was on the verge of sentencing that it came to light that there was this lacuna in our legislative structure. Now, the importance of the Fingerprint Act, as I've already said, under Section 3, it says where a person is charged before the circuit court, traffic court, children's court, family court, or parish court with any offense specified in the schedule. So if it is not in the schedule of the Fingerprint Act, the court does not have that statutory authority to order the prints. Now, Section 4 of the Fingerprints Act also demonstrates the other utility of fingerprinting particular persons charged under for serious offenses. It says, if the person who is fingerprinted and photographed is convicted of an offense specified in the schedule, the conviction and sentence shall be recorded in the space provided for that purpose. So what the Fingerprints Act does, it also creates a regime for all these serious offenses where the conviction themselves are now recorded on the fingerprint form for the particular accused or convicted person. So Joint Select ought to consider that it is very important that if someone is convicted for a cyber offense, that no one is able to use legal semantics, that the statute authorizes, 1, the fingerprint to be taken, and 2, for the conviction to be recorded. And I will not belabor the point any further because my submissions go into it with great detail. So at this time, I will hand over to Mr. Brown, who is going to treat with the issue of malicious communication. Thank you very much.
Mr. Chairman, before she goes, may I ask a question, please? Seek clarification. Mr. Chairman?
Sure, go ahead, go right ahead.
Thank you. Thank you for that presentation. I just have a quick question regarding the High Court. I hear what you had to say about adjusting the legislation so that the matters can be brought to the High Court only in front of a judge. So we would do away with the need for a jury. My question is, if someone were to disagree with you, what would be their argument for the disagreement?
If someone were to disagree, and I've heard this argument being raised in legal circles, that there is a belief that slowly we are reducing the number of matters that are tried by judge and jury. And there is almost a concern about that. But what I say in respect of the cyber matters is this. Presently under the Cyber Act, and it was so under the 2010 Act, a parish judge sitting alone can adjudicate over a cyber matter. So what justification in law would there be to say that a High Court judge sitting alone cannot deliberate or adjudicate over a cyber matter? In fact, cyber is different than the other offenses that are triable by judge alone. When you look at your gun court offenses, illegal possession of firearm, your woundings, etc., they are not triable by a parish court. Your lottery scamming matters are not triable by a parish court. Human trafficking is not triable by the parish court. Murder is not triable by the parish court. So therefore, if you would allow for those offenses, which are very serious offenses, to be tried by a judge alone in the High Court, why can't you allow for a cyber matter, which already the law says a parish court judge sitting alone is competent to adjudicate over? Why isn't a High Court judge also similarly competent to adjudicate over it sitting alone? So I think the only apprehension probably from the Bar Association or so may be you've allowed for human trafficking to be judge alone. You've allowed for the lottery scamming matters to be judge alone. Now you're an anti-ganger judge alone. Now you're inching into cyber. And the apprehension that slowly the jurors are being used less in the judicial system. I think that would probably be the main anxiety.
Thank you.
Chairman, on that point, and I think Council summed it up nicely, that there seems to be a strategic move spearheaded by the Office of the DPP to remove the jury from all criminal matters. I have my own view on it. I don't know if in anti-gang it has served you well, but nonetheless, it appears that that is the direction. I think this matter does make a strong case for it because of the technicality, but I do wonder, and I'll ask, how have the High Court matters gone? Do we have any documentation, numbers, of how many matters have been taken in the High Court? What have been the outcome? How has the jury interacted with these matters?
I was going to say, I was waiting on the defense bar lawyers to comment on this, and I wondered how there was so much silence, because we do have a lot of defense lawyers on this committee, but I know it wouldn't pass the full house with the defense lawyers.
But we need to get a clarification first. I think Minister Green is speaking in his capacity as Minister of Agriculture. I'm not a lawyer.
Absolutely, 100%. Thank you, Chairman. Thank you.
What I will say, Minister Green, is that because the matters would have to be tried before a jury, we seldom take up these matters to be tried in the High Court. But what we do is this. Because the law reform matters are tried by judge alone, if we have a law reform matter where we see also some unauthorized access, then we attach the cyber offense to the law reform and we piggyback on the judge alone trial. I see that I'm being recorded, but it's a strategy because what the law allows is that we can try a jury matter with the judge alone matter, and depending on how it is done, we can benefit on the strength of the judge alone. So the law reform, which is a lottery scamming, is your judge alone. The cyber is a jury, but we can add the cyber to the law reform indictment. But I think, Minister Green, and I'm happy with the comments you made, I cannot see how someone can stridently oppose the jurisdiction of the High Court, sitting judge alone, in a case where a parish court judge is already authorized in law, are deemed to be competent to sit alone to deliberate. The Supreme Court judge is actually, and I want to phrase it properly.
I appreciate the point.
Thank you very much for appreciating it.
But you know, the solution to that point doesn't mean that you normalize it in the High Court. The solution to the point may mean we should look at removing the power of a parish court judge being able to treat with these matters. The solution is not necessarily that you now make the High Court be able to treat with the matter by judge alone. And you know, I say that against the background of I'm hesitant, especially when you look to elevate the penalties, which I think you again have made an unassailable case about raising the penalties, right? But again, I genuinely believe that the higher the penalties are, is the more we should protect one being tried by their peers.
Yeah.
And therein lies my difficulty. So I'm really with you to say that, listen, the starting point needs to be higher, especially because what I do find in these cyber matters is that the evidence against the person is so overwhelming that they will be moved. You know, in putting the case together, a lot of them have no choice but to plead guilty. So I definitely believe we should be at a higher starting point, and I support that 100%, that we should move up the maximum sentences so the judges are starting higher when they're discounted. But when you do that now, I now feel the need to say that, boy, we really should ensure that if we're going to say that a man can go away, if we're moving from 7 years to 15, that a jury should be a part of the process, right? So it's a difficult dilemma.
So remember, from a layman's standpoint, I mean, obviously this is a legal issue. But when I think, and I agree 100% in relation to the fines, and I gave the reason why, because basically at this point, I mean, 34 million as against 340 million is the same penalty. But more importantly, the sophistication of cybercrime. The question I ask is whether or not a jury can really understand the intricacies of the case to make a proper judgment as against a judge who obviously is trained and understands the law and of course the process. So whereas I get you in relation to the jurors, I'm only saying as it relates to cybercrime, that may be a different a different take from my standpoint as a layman.
And to be honest, Minister Chairman, I get that point. I take that point. The only thing is that, you know, that's why you have counsel and that's why you have skilled counsel at the DPP's office who really do an excellent job of breaking down these matters so much. As you have heard in this presentation, I'm sure everybody agrees with me how excellent all of us as lay people understood. And that is how they do it for the juries. And I'm telling you, Chair, I know one case and I see that the DPP herself has commented. There was one very pronounced case in the media, an anti-gang case, that I am 100% sure if that was jury, the people would be behind prison. They would be behind bars. So the DPP, you know, sometimes in trying to be efficient, sometimes, you know, the layman is sometimes better able to recognize criminals than even those who apply a legal mind to evidence that is assessed. Anyway, thank you, Chairman. We can proceed.
Chairman, if I may.
Sure, go ahead.
I just want to chime in here. It is clearly highly a legal matter, but I am also recognizing the effort to recognize due diligence for justice being served. And I am very wary. I am definitely in agreement with the increased rates, fines, etc., etc. But in terms of the deliberation to remove the jury, I wonder if there's a hybrid situation where perhaps we can have a lessened amount of jurors. But I think to leave it solely to the role of the judge in that determination, especially with the higher penalties, we might be erring on the side of too much caution. And I think that may not see the deliverance of the justice and the meaning of the law that we might intend. And so I wonder in terms of an adjusted amount of jurors being required or input from that level in terms of the consideration of the penalties. Just my input there. Thank you, Chair.
Thank you very much. Council, you wanted to go back to your presentation?
No, I was just responding to what Ms. Longmore had just indicated. At present, there are 7 jurors who would try these matters. In fact, it's 7 jurors that are impaneled now across the board to try most of our criminal cases, save and except capital murder, which requires 12. I don't know.
Perhaps 3.
That may be difficult. I think that may be very, very difficult.
I think it's a medium that could be considered. I don't know, that's just my opinion, but I think to leave it to one particular mind, though very educated and though very competent, I think that the reason we have a jury process is we still need to bear in mind.
Okay.
Thank you.
Very well. Yes, I'm finished now. Mr. Brown, through you, Mr. Chair.
Hi, good afternoon, Mr. Chairman, ladies and gentlemen of the committee. I trust everyone is hearing me loudly and clearly.
Yes, you have a tall order to follow, you know. Excellent.
I recognize that, so let's hope I keep a pace, right?
Okay, good.
So the aspect of the presentation that I am asked to discuss is concerning Section 9 of the Cybercrimes Act of 2015, and that deals with malicious communication. And as the presentation from the Ministry of National Security made clear, malicious communication is one of those offenses that is very heavily used under the legislation. And what you find is that even when the matters don't go to court, we routinely receive calls at the office trying to get guidance about whether or not certain offenses attain the standard and that so they could be charged under Section 9. Now, in the bundle that we have supplied to the committee in our submissions, at the last tab, you will note that there's a guidance from the Office of the Director of Public Prosecution setting out how we go about assessing those matters that come in to see whether or not they actually meet the requirements. It's a very high threshold. So what we have looked to do, and a part of our recommendation, is to look at how the actus reus, meaning the act that is considered malicious communication, or it is done, or we treat with that. Because presently under Section 9, what you see is that it refers to the sending to any person of any communication that is deemed malicious. And to place a submission in its proper context, I want to share a scenario with us where we received a call recently where a lady was indicating that she had ended a relationship with her partner, and the partner had posted a photo including her on his WhatsApp status. She was performing a sexual act. No, it was not sent, it was just on his status, readily visible to all persons who access his status. And we found that we were a part of the discussion we had to undertake is to conclude or decide whether or not that amounted to sending to another person under the legislation. And we found that a part of the difficulty we faced is that the act presently does not define what sending to is. Now, we could argue, as is argued in our guidance under Section 9, that sending to also includes publishing. But it is our submission that given the importance of this section, nothing ought to be left to chance, or nothing ought to be left to conjecture or to being construed by different minds, because different minds might arrive at different conclusions. So one of our main submissions is that we should revisit the definition of sending to, or at least create a definition of what sending to is under the legislation. Is it that if you publish it, it becomes, it is one of the offenses? Is it that if you make it available, if you make it accessible by electronic means? What are the several means by which you can send an image that would amount to malicious communication under Section 9? So what we are asking is for the committee to consider perhaps enlarging the definition of the actus reus. Now, you will recognize that what we have done is that we have considered we have looked at the UK legislation, and what you find is that in the UK legislation, there is that definition, right? And that is the Malicious Communications Act of the UK, 1988. So we are asking for us to consider enlarging the actus reus so that we escape the situation where we are trying to construe what is the intention of Parliament. It will significantly enhance the ease with which we can prosecute these matters, and that is acknowledged, and that is what we are aiming for, because presently, as I said, it is sometimes a little difficult to prosecute many of these matters that come before us.
All right, Mr. Brown, is that under the guidelines of prosecuting in terms of the definition?
No, I'm sorry?
The definition of that you are trying to explain to us now, which one of the tabs would that be included in? Well, I'm looking at the guidelines of prosecuting.
When you look at tab 8, that is the guideline for prosecuting cases involving malicious communication section.
Yeah, that's the one I'm looking at.
The Cybercrimes Act. No, that is the guidance. That is just the guidance. This is what we look at in determining whether a matter that is placed before us meets the threshold requirements under the section. The definition, there is presently no definition in the legislation as to what sending to another person means under Section 9. So what we are trying to ask the committee to consider rectifying is to amend the legislation to include a definition outlining all the possible ways in which someone could be found guilty of sending malicious communication. So is it that if you publish it, it is also considered sending to? Is it that if you make it accessible to someone online, it also falls afoul of the legislation? So for instance, in the scenario that I indicated first, if we had a definition of publishing, for instance, or making it accessible electronically. One could argue that the fact that you place it on my WhatsApp status, a social media platform, anyone on that media can access it electronically. So that person would fall afoul of the legislation.
Understood. You're pointing us to the UK definition?
Right. No, the UK definition, if you look at page 8 of the written submissions, what you'll find is that at paragraph 3, which starts in the UK Act, the legislation explains what qualifies as sending for the purpose of the particular section. Section 1.3 states as follows. In this section, references to sending include references to delivering or transmitting and to causing to be sent, delivered or transmitted, and sender shall be construed accordingly. And we mirrored the malicious communications at 1988, and that is found in tab 4 of our submissions. Now, while we mirrored the act, that act does offer a definition for what sending to is considered legislation. But we did not mirror it to that extent where we defined under our legislation what sending to is, right? And that is what we're asking the committee to consider, including a definition. And what we are suggesting is that as many ways in which a document can be published or sent electronically ought to be included in that definition so that a wide breadth of offending can be captured very readily.
Got you.
We have also proposed for your consideration the inclusion of a new offense. And this is in relation to offenses that are loosely termed revenge porn offenses, revenge pornography offenses. And what we are seeing across the Commonwealth, the UK, Canada, Australia, is that there is a move towards criminalizing the unauthorized release of what is considered private images. Now, at tab 5, you'll notice that we have included the UK provisions under section 33 and 34 of the Criminal Justice and Courts Act 2015. And this now creates a standalone offense, which is titled Disclosing Private Sexual Photographs and Films with Intent to Cause Distress. And it goes on to state that it is an offense for a person to disclose a private sexual photograph or film if the disclosure is made without the consent of an individual who appears in the photograph or film and with the intention of causing that individual distress. Now, statutory defenses are included under section 33 because it is not an offense to send the image to the person depicted in the film or photograph. Neither is it an offense to disclose the image where such disclosure is made for the purpose of detecting, investigating, or preventing crime. It defines disclose, and discloses means a person discloses something to a person if by any means he or she gives or shows it to the person or person makes it available to the person. Now, it goes on to divide what private and sexual matters are. And a photograph or a film is private if it shows something that is not of a kind ordinarily seen in public. A photograph or a film is sexual if it shows all or part of an individual's exposed genitals or pubic area. Now, we are proposing that the treatment of the revenge porn cases as a consent-based offense is a direction that we should follow, because what you find is that many times there is an increasing incidence of jilted lovers revealing images that were privately taken, and usually these images involve nudity or displaying the victim in some compromising position. or some position that is likely to cause embarrassment to the person. So it is without their consent. And it does make it a lot easier to prosecute because, as I said, under malicious communication, while there is an element for where obscene images might be considered malicious, the threshold under that section sometimes is very difficult to meet. And what you'll find is that if one just publishes the image on the WhatsApp status without more, then you may find it difficult to prosecute the person under Section 9 because all the elements under that section might not have been met. So this standalone offense that is being proposed would make it easier to prosecute that matter once we can establish that the image was published and the person did not consent to the image being published. We have also looked at the approach taken in Canada, Australia, and the Caribbean islands, and we have included these for the committee's consideration, especially as it relates to defining the actus reus. Because when one looks at the Canadian Criminal Code, the actus reus, and this is included at tab 6, the actus reus includes publishing, distributing, transmitting, selling, making available, or advertising. So any one of these activities can run afoul of the law. Again, the wider the number of categories that is criminalized or that are criminalized, the easier it is for the law to keep up with the change in technology, because technology is changing so rapidly. The manner in which things are published on the internet or published electronically changes daily. So it means that the wider the breadth of the actus reus, the more likely it is that the legislation will keep abreast of the changes as technology develops. Now, as indicated, there is no definition in the Cybercrimes Act. So even in relation to Section 9, we would wish to commend these different activities as a part of that definition going forward, because we are saying that there is still space for Section 9 of the Cybercrimes Act. We're just proposing another section to deal discreetly with those cases that can properly be called revenge porn cases. But the definition, the breadth of the definition would serve a useful purpose under Section 9 of the Cybercrimes Act. Now, when you look at 162.11 of the Criminal Code, it says everyone who knowingly publishes, distributes, transmits, sells, makes available, or advertises an intimate image of a person, knowing that the person depicted in the image did not give their consent to that conduct, or being reckless as to whether or not that person gave their consent to that conduct, is guilty. Intimate images is defined as an intimate image means a visual recording of a person made by any means, including a photographic film or video recording in which a person is nude, is exposing his or her genital organs or anal region or breasts, or is engaged in explicit sexual activity, in respect of which at the time of the recording there were circumstances that gave rise to reasonable expectation of privacy. Again, the reasonable expectation of privacy is an important consideration. It will be a matter for the committee whether or not it wishes to include this aspect as a requirement under our legislation if the proposal is accepted. Because what the Canadian Code is suggesting is that these images are usually shared with the person in the intimate and private relations between two persons. And that person has a legitimate expectation to expect that they would be kept private, that they would not be shared without their consent. So that is an aspect that ought to be considered as well if our proposal is accepted. Now, we also looked at the Canadian approach under the Criminal Code in 2019, where it was amended and to include the Criminal Law Amendment Intimate Images Act 2019. and the statute is at tab 7 of our submissions. And we have drawn your attention at page 11 of the written submission, specifically to section 221 BD2, which states as follows: a person commits a crime if A, the person distributes an intimate image of another person, the depicted person, and B, the depicted person does not consent to the distribution. The penalty there is imprisonment for 3 years and summary conviction, imprisonment for 18 months and a fine of $18,000 Canadian, Australian dollars. So what you recognize that the common thread through these offenses is that it's a question of consent. It's consent based. In all these offenses, the absence of consent is critical to the offense being committed. And the mischief that is being addressed is the very revelation or publishing of private images without the consent of the person depicted in the images. And that is what we are seeing an increase of in our discussions and our interfaces with the public, who sometimes call us either directly or through police officers seeking guidance as to how to prosecute these matters. And regrettably, many times it would be imprudent to initiate criminal proceedings because there is really no reasonable prospect of securing a conviction under Section 9 of the Cybercrime, the current Cybercrimes Act. So the rationale, therefore, is to protect those persons who might fall victim of someone who maliciously reveals private photographs that cause those persons, the victims, serious distress. Now, interestingly, in the Australian definition of distribution at section 221 BC, it says a person distributes an intimate image of a person by A, communicating, exhibiting, selling, sending, supplying, offering, or transmitting the image of a person to a person other than themselves or the person depicted in the image, or, importantly, making the image available for access by electronic or other means by a person other than themselves or the person depicted in the image, or entering into an agreement or arrangement to do anything referred to in paragraph A or B. Now, we have underlined subsection B, and we want to place specific attention on this particular mode of committing the offense, because what you'll find is that many times the image might not be sent directly to someone, but it may be uploaded, for instance, on Pornhub, where any person can access it electronically. The victim might not even be aware that the image or the video or whatever image of them has been placed or published there, but the public can access it electronically by just going to Pornhub and looking at the video. So if it can be proved then that the person who sent that image did not receive the permission or the consent of the person depicted in the image, and it is clearly accessible electronically, you might find that if we include such a definition in our legislation, we might be in a better position to prosecute persons who do this kind of activity. And it is happening more frequently than we know, where you see images of persons appearing on Pornhub under different titles and headings. Now, in this so we would commend certainly adopting where necessary certain elements of these definitions, certain elements of the definitions across each legislation. The different modes, in our view, would prove useful and would also go to assist prosecution of offenses under Section 9. So while yes, we are proposing this standalone agreement, this standalone offense, we are saying that if the definition is extended to Section 9, it will inure to the benefit of the prosecution of these matters, generally speaking, both under malicious communication and under any new legislation that is proposed, that is created or crafted for revenge porn offenses. So in wrapping up what we are, the thrust of our submissions on this aspect of the proposal is that, one, we define the term sent to another person. And while we have limited at paragraph 1 on page 13 in the context of the approach taken by the United Kingdom, we would certainly commend you a wider view to look at all the definitions that we have outlined from the Commonwealth to see how we can incorporate other aspects, other elements, or other modes of committing the offense into Section 9. We also should, as we outlined there, we submit that the accessory should be enlarged to specifically speak to actions such as making the image available for access by electronic means, transmitting the image, data, exhibiting it, and distributing it. And as we are indicating there, it is critical because several reports which have been made by individuals concern the data being placed on website or on social media platforms such as Facebook, Instagram, and Twitter, or even on the person's WhatsApp status or profile. And each of the elements that we have indicated here, these are actually actual cases that might not reach the court, but reports that have come either through the police or to the Office of the Director of Public Prosecutions. It is important that we remove the current restriction that the data must be sent to another person before the offense is committed, because it is being committed in other means now, and those persons are escaping the grasp of the criminal law as it is currently crafted. By restricting, we have also proposed that we remove the term obscene from the malicious communication section. Again, if the proposal is accepted that there is this revenge porn offense, then the obscene, we would need to look at the interplay between the obscene in Section 9 and what is contemplated by the new proposed section dealing with revenge porn. We are proposing that it be a consent-based offense as opposed to an arm-based offense which obtained with malicious communications. Now, we are also proposing that we perhaps should consider defining what menacing is under Section 9 of the Malicious Communications Act. It is a term that we have certainly grappled with from the inception of the Act in 2015, and in attempting to advise both prosecutors and police how to view that aspect of the legislation. So perhaps it is something that ought to be considered. We have included the guidelines at tab 8, and tab 8 and the guidelines do have a discussion about what is considered menacing based on some of the authorities that were reviewed. So it is our view that by defining the term under the legislation, again, it removes any room for confusion about what the term is or what is required to constitute the offense. And I believe more than anything, what we are striving for is clarity in the section so that it can be properly used and properly employed. So those are the submissions as it relates to Section 9 of the Cybercrimes Act, as well as the proposal of a standalone section dealing with revenge porn types of cases. We commend the views, we commend the position taken by those countries in the Commonwealth that have gone ahead and have created such offenses. And we believe that there are elements of those offenses that can be adapted to the Jamaican context. I am open to your questions, should there be any.
So, Chairman, could I just ask? First, I want to agree that the definition of menacing needs to be done. As you said, we grappled with Section 9. It was the most contentious part of the legislation the last time. on the issue of revenge porn, and obviously you deal with the issues from a prosecution perspective, but we've always shied away from being offense specific in the legislation, simply because what is the, I don't want to say the flavor of the day now, may be very different 2 years from now, 3 years from now, in terms of how offenses evolve over time with the change in technology. So my question is there no other way to capture what is in effect revenge porn in the existing legislation without making it specific? Because you may have to come next year to amend for whatever is the new or the prominent type of offense next year.
Well, unless it is that we are going to include under Section 9, perhaps a subsection dealing with the publishing of private images. If it is that we don't want to do a standalone section without creating a new offense. But presently, are we wind the definition to capture the conduct that we consider revenge porn, which is an unauthorized publication of private images. So it would mean then that we perhaps would have to revisit the section, revisit definition to capture all the elements of the offending where private images are released. But what we were trying to do, the mischief that we were trying to avoid, recognizing the fluidity of technology and recognizing the fluidity of how information is published and accessed electronically, is to, in the standalone provision, to create a wide enough definition that would likely capture any possible means of publication of those images. That is what we were considering when we made the proposal. Alternatively, we would have to incorporate it in Section 9 by widening the definition and widening the elements contained in that section.
All right. You understand the concern I have, which is I don't know what may be the next big thing next year, which again, if you make it specific, but if you say you're going to be broad enough that you believe it could be capture other things, then I might be more comfortable. But I just have a little, just as a general principle around putting in those specific things versus having legislation which covers the type of offense that you're talking about.
And I appreciate that, because you can't have legislation being changed ever so often. Right. But if we consider this aspect though, I do not think, I mean, Mark, I don't have a crystal ball seeing down the road, but this particular offense, I don't think we'll see the back of it anytime soon. I believe this is one offense that is likely to remain consistently throughout the years, especially as technology advances, especially as our lives become so interconnected. It is more likely than not that we are going to see these types of offenses continuing or becoming even worse going forward, just based on what we have seen over the years.
May I also say something in response to you, Mr. Robinson? What we realized is that, in fact, in 2015, when the legislation was reviewed, that was the same year when the UK had introduced their violation of privacy offense. And what they did was they retained the Malicious Communications Act, but then they separated the violation of privacy. And all the other territories that we have examined have done the very same thing. And I think why it perhaps cannot be subsumed under Section 9 is because when you look at the sections that Mr. Brown has alluded to and which are attached to our submissions, the offense of violation of privacy is a consent-based offense. Section 9 is a harm-based offense. Section 9 says if you send the data, which is obscene or menacing or constitutes a threat, with the intention to cause harm, that's the essence of the offense, your intention. The consent-based offense is saying, I have shared my intimate image with you, but I have an expectation of privacy and you have violated my expectation of privacy. But when you look at what Australia and the other territories have done, they not only define intimate images, they also speak to the consent, they speak to what is distribution, so they cover it, it's much wider than the sending to another. And as Mr. Brown has said, and I just want to also emphasize what he has said, sending to another person is the most limited way a legislation could speak to this type of offending, because the legislation says, I, as the prosecutor, Mr. Brown and I must prove that you sent it to a person. And we live in an age now, and it, as Mr. Brown says, it continues to evolve. I don't have to send it to somebody. And then what the Cyber Act of 2015 did is that it doesn't even define what is send. Whereas even the UK Malicious Communications Act, which speaks to sending, defined specifically what is sending. So a lot of times, as Mr. Brown says, people say, I see my genitalia on the internet. The genitalia is placed on a platform. It is, yes, you may say, but isn't that inadvertently sending it to another person? But the legislation must define, and the legislation doesn't have to say sending means. It can say sending includes, so that it is clear to the judge, clear to the lawyers, clear to the investigators, that this is what Parliament intends when they said send. And when you look at everywhere else, Jamaica is the only statute now that does not even define what sending is, sending to another person is. And then secondly, when you speak to the violation of privacy offense, why I think it has to stand alone is because when you look at the other territories, they establish statutory defenses to the offense. So it's not just a wide offense, it creates a defense. For example, if it is done for educational purposes, medical purposes, because you have to expose private images in a medical setting. Sometimes it is exposed for scientific reasons or research. It also creates a defense where it was reasonably necessary for legal proceedings, and all of those things. So I don't think the consent-based offense can simply be subsumed. I think Joint Select ought to really look at how the offense is treated in other jurisdictions, and that the revenge point stands alone. That's just my
Okay, all right. I mean, I'm
Sure.
sufficiently guided by that, yeah.
Chair, I just have one thing of clarity. In terms of the distribution and consent and the expectation of confidentiality, I'm seeking clarity whether this is just limited to what is visual in nature, or does it include what can be audio? There's a tendency today that you send a voice note and that voice note is distributed widely in nature. Are we limiting this to just what is visual, or does it include, was there a contemplation for it to include what may have been audio?
You want to take that one, Obi, or?
Well, the contemplation, as far as I know, was what is visual, because that is the nature of the offending that is causing the most concern now. It's not necessarily what is recorded, what is audio. So the nature of the offending is largely visual.
If I send you a voice note that was meant for your ear alone, and you now distribute this voice note where it becomes viral in nature,
right?
It offends me,
right?
How should I treat it? I'm saying this right. Today because as you have represented, in 2015, the Act never took this into consideration. Now, today, these things are becoming more prominent in nature. And so one has to consider how we can treat these acts that have become somewhat prevalent and has caused harm on persons.
I mean, it is something that certainly, from my perspective, I'd have to take have to consider further because, as I indicated, the offense is largely visual in nature. The revelation of an audio recording, several things might affect it. What is the content of the audio? Is it a negotiation in between players and staff that is sent out? What is let's use a current malicious communication act. Is it obscene? Is it menacing? Is it threatening? Is it meant to harass? So it is something that perhaps we'll have to consider separately, but currently the offense, as far as we know it operates, is largely where private images of usually a person doing acts that are sexual in nature are published without their consent.
Can I ask a question? Just thinking out loud. I mean, we have a very bad habit in the country of sending images of persons who are shot in accidents, that kind of thing. Would that rise to being a criminal offense if I took a picture of somebody who was just shot, still alive, and then post it all over the place?
Are those, Julian, who meet in an accident and is suffering?
Not under Section 9.
Wouldn't be under Section 9.
No.
Because the intent isn't there?
Yeah.
Because of intent?
You're sending it out, perhaps you're thinking you're sending it out for informational purposes.
Well,
the Ministry of National Security in their submission, Julian, made representation around those sent in of a graphic nature.
Yes.
And so we may want to consider that. It came to my mind, it was one of the questions I was going to ask around, the submission made by them.
No, I mean, under Section 9.
In terms of under Section 9.
It would not qualify under Section 9. If you just look at the terms of Section 9, it would not qualify.
Well, it was proposed to be such in considering the psychological impact on the 9/1.
Yeah, yes, it was proposed.
I don't know where it would be captured, but I think it's something to consider because it can have and does have in many cases even a more deleterious effect than somebody sending a nude picture. I mean, where families see things before they're known and that kind of thing. So I don't know where it would fall, but I think it's something to consider.
Well, I see where the Ministry of National Security want to respond possibly.
Yes, Mr. Gale, I do support your point with respect to maybe we have to change the entire word in
not hearing at all.
Obscene. Not hearing? Can you hear me? Yes?
Hearing you.
All right, right. So I am supporting what you propose, Mr. Gale, because in fact, we have included that in broadening the definition of obscene.
Very low, very low.
Closer. Can you hear me now? Or you are the only person hearing me low?
It's so low, but we can't hear it. We can work with it.
Check it, I'm going to work with it. Right.
Okay, right. So I'm saying I'm supporting Mr. Gale's point. In fact, we had made that suggestion in terms of obscene to not only include a picture which shows something of nudity, but of course, Mr. Gale mentioned voice notes, which can be classified as something that is obscene also. So probably we'll have to change that confusing word of obscene and make it a little bit broader. And Member Robertson had mentioned too about what about graphic incidents where photographs are taken and circulated. How do we capture that? So, probably we'll have to change that whole definition of obscene and to include the more definitive things that are displayed within that cyber form in terms of things that are new, things that are said, and other than just images.
I mean, I give two examples. I think Kobe Bryant's wife, and I could be wrong, I just reading from news, I think she sued the police department in LA, wherever he died in the plane crash, for sharing images of the scene and etc. before, they were notified. And I mean, I'll tell you, I saw one yesterday of an incident in, I think it's Arnett Gardens, where 2 people were killed execution style. And I mean, if I was a family member of one of those persons, it's probably one of the most distressing images that I've seen in a long time. And all of us get these things every day. We have to find a way to curtail this propensity to take the pictures, often in violation of certain people's privacy when they are even still alive, and certainly out of some respect for the dead and the relatives of the dead.
I agree totally on that, Member Robinson. Absolutely.
Yes, so, Mr. Chairman, ladies and gentlemen, those are the submissions to the Committee on the Review of the Cybercrimes Act of 2015 by the Office of the Director of Public Prosecutions, unless there are other questions, of course.
There's just one question. Under the case summary, the cases that are not disposed of, are they carried over into the next report? Okay.
Yes, they're brought forward to the following.
Thank you. To the following year. Okay. All right.
Chairman, I missed some of the presentation, but just to put on record that I strongly support the move by the Office of Public Prosecutions to really have a separate segment that treats with matters such as revenge porn and things of that nature. I think that is the movement across the world, and I definitely believe it's something that we should take on.
I think we're all on one with that, Member Green, for sure. I think the both presentations have been very, very well presented. Good information, and most importantly, good recommendations across the board. And I think it is, well prepared and informative.
Well researched, Chair.
Well researched, absolutely. It's been very, very, very well presented. And I'm sure that we will get deeper into it when the time comes for the final recommendations. So I want to thank both Ministry of National Security and the presenters and the Office of the Prosecutions. I think it has been, been a long afternoon, but very well worth the time. So at this point, members, I think we can move on now to, let me just get my file here. Yes, members. Ms. Brandon, what is in terms of dates, next proposed dates?
The next available date is June the 16th at 10 a.m.
June 16th at 10 a.m. And in terms of the next presenters?
The committee can make that determination, Chairman.
I don't really have any particular order from my standpoint. I don't know if any of the members have any specific order that they'd like to invite.
Once they're ready, we take them, Chair.
So Ms. Brandon, we just schedule those who are available and ready for that date.
So should I schedule 2 entities to make presentation at the next meeting?
Sure, absolutely. We want to get through as quickly as possible. Is there any other dates after the next date that we can set from now?
I don't have that available with me now, Chairman.
All right, can you get us some dates so we can circulate them and see what we can set in terms of timelines from now, based on the schedule of the Parliament. All right,
Chairman, may I ask, will that be another virtual meeting?
Sure.
Okay,
sure.
I have another commitment at that time, so I'm just trying to see if I can do both. Thank you.
Sure. All right. Can we go to AOB? Any other business? Anybody wants to raise anything? All right. Well, once again, thanks to members.
Before
go ahead.
The University of the West Indies has requested an extension to June 18 to make its submission. I did not receive the consent of majority of the members, so could you just dispose of this matter at the meeting?
Sure. I personally have no objection to that. I know they have a burning issue that they want to present, and I think they need some more time to do their research for the presentation. So I have no objection if the other members will concur.
No objection.
No objections.
All right, so we go with that. You can notify them, Ms. Brandon.
Thank you, Chairman.
All right, so members, thanks a lot, all of the presenters, and of course, all the other agencies of government and arms of government that are a part of the committee. Thank you very much, and we see you on the 10th, Ms. Brandon?
The 16th of June.
16 at 10 o'clock.
At 10. Yes, Chairman.
Thank you very much. Everybody, until such time, keep safe and have a great afternoon.
All right, Chair. Okay, everyone.
God bless.
Bye. Keep safe, everyone.
Yo, this is we're committed to reducing the impact of disasters occurring in Jamaica. We're ever ready to assist you before, during, and after a disaster. But everybody